Well, good morning. We're a couple minutes after noon, and welcome to Reconstructed. This is the virtual version of Lewis Thomason's annual construction law seminar. Normally, we give an annual seminar in each of our three offices in Knoxville, Nashville, and Memphis. But due to COVID, we have gone online this year to try and provide monthly content on more of a lunch and learn series. And we'll talk a little bit about that at the end and give you some more options of what's to come here in the next few months. But I appreciate you joining in today. If you've got any questions as we go forward, today we're going to be talking about the Tennessee construction statutes and revisions that were made about a month ago, month and a half, as part of the Construction Industry Payment Protection Act. This is a bill that passed that provided comprehensive changes throughout the construction statutes here in Tennessee and provides a leg up for the construction industry as a whole in terms of being able to ensure that payments that are due on any sort of construction project are made in accordance with the written contract between the parties, as well as some base guidelines that are contained in the construction statutes themselves. As we go forward today, if at any time you have any questions, feel free to type them into the chat feature within Zoom. I'll do my best to try and catch those as we're going along. That way, if you have a question on something in particular, you can go ahead and ask it and we'll try and address it then. Also, feel free, if you want to wait till the end, that's fine. Just feel free to go ahead and put those in at any time. And like I say, we'll try and get them as we go along. But today we're talking about the Construction Industry Payment Protection Act. And again, this is a series of comprehensive changes to all of the construction statutes here in Tennessee. So when we talk about construction law, we're talking about a number of different things. Specifically, as you can see here, we're talking about the construction lien statutes that anytime a design professional provides services on a project or a contractor provides labor or materials, they're entitled to some sort of security for those services and materials. And in Tennessee, that's called a mechanics and materialman's lien. We'll talk about the specifics of that in a moment, but at the end of the day, what that does is provide an avenue, if you're not paid, to actually sell the property that was improved and that you provided services or labor or materials to, and allows you to get paid through the sale of that property. It's very rare that a property is actually sold here in Tennessee, but a lien does encumber the title and requires an owner of that property to take action to try and remove that title, most often working out a deal to make sure that you're paid. The second is the Truth in Construction Act. This is a Consumer Protection Act statute that applies to the construction industry. Originally, it was intended really to address some issues that were present in residential construction and really are not that present in the commercial construction industry. So there was a need to take some action to address some of the potential issues that can arise in consumer protection. There requires a couple of pre-construction notices that are required if you have a contract with the owner. Provides an owner an out for a period of 3 days if they have any issues with the contract. And again, in terms of residential construction, that's something that makes sense. Give somebody an opportunity to look at the contract as opposed to signing an agreement that they may not understand or may not have an opportunity to read in full. Whereas in commercial construction, you're dealing with sophisticated parties. They all, most of the time, have attorneys or they've dealt with construction enough that they know what they're looking at and know how to understand it. And so there's really not a need to protect those types of parties in the commercial construction industry. The third is the Prompt Pay Act of 1991. This is generally the statute that sets forth when payments have to be made, how they have to be made in terms of progress payments. It provides some specific restrictions on what retainage is withheld, how much a party can retain, and even if they do withhold retainage, how long that is and when that retainage has to be paid. It also sets forth a number of requirements of where that retainage has to be withheld or where the retainage has to be placed in a third-party escrow account to make sure that it actually is maintained separate and apart from the other construction funds, as well as some penalties if retainage is not withheld properly in accordance with the Prompt Pay Act. Finally, the construction defect statute. A lot of times, construction defects in Tennessee, you have to provide notice and opportunity to cure. This is something that's normally addressed in the written contract between the parties, but in the event there is a third-party claim, or if you're a subcontractor, construction is over and an owner has an issue, it's an owner-specific statute, so that if the owner has a claim, it provides a lengthy and very detailed procedure as to how you provide notice from an owner to a contractor or to a design professional, and then how that works its way down through the various tiers of contractors and consultants, so that you can ultimately try and resolve the defect. And if you're not able to do it, at least find a way to get that cured, to provide everybody a notice that there is an issue and give them an opportunity to fix that if it's something that one of those parties is actually responsible for. So talking generally about these statutes, we did that a second ago, a little more specifics for those who are not as familiar as others. In Tennessee, again, with the construction lien laws, some of you who have been in business for a while will recall that prior to 2007, the mechanics lien laws were very detailed. They had a lot of definitions. They used a lot of industry terms and really categorized people by what they did as opposed to who they had a contract with. And this created a lot of opportunities for confusion. It created some gap periods that really made no sense. So, if you were an architect or an engineer, you had a very specific procedure to you as to how you went about enforcing a mechanics lien. The same thing with general contractors or subcontractors and even suppliers, surveyors as well. And so it was one where there was a lot of confusion back in 2007. The industry went through a procedure to try and make it a little easier, a little more straightforward. And instead of worrying about who you were, the lien statutes were amended to focus more on who you had a contract with. If you had a contract with the owner of the property, you were a prime contractor. If you had a contract with anyone else, you were a remote contractor. In terms of prime contractors have a lien that lasts for 1 year from the date the project is completed. It's important to distinguish between completion and what we often refer to completion as, which is substantial completion. For purposes of the lien laws, all we're focused on is 100% completion. So if you're a prime contractor and you have a contract with the owner, you have a lien and can enforce that lien up to 1 year from the date of completion. If you're a remote contractor, you have to jump through a few more hoops. And really you're abiding by what we refer to as the rule of 90. So if you're a remote contractor, you have to provide a notice of non-payment that has to go to both the prime contractor and really it's preferable to send it to anybody within the contracting chain between you and the owner. So any notice of non-payment's got to go to as many people as you can upstream of you and include the owner. And the purpose of that, same thing with defective work, a notice an opportunity to cure. It provides the owner an opportunity to make sure that you can get paid or to pay you themselves directly to try and prevent an encumbrance from being asserted against their property. That notice has to be sent within 90 days of the last day of each month in which you provide labor or services to the project and the property. And then again, it's for each month. If you have work that was performed in January, you have to send a notice by the end of April in simple terms, saying, hey, I haven't been paid, raising your hand, letting the owner know that so they have an opportunity to make sure that you're either paid or withhold money from the general contractor to cover whatever amount you're owed until you are paid. If you ultimately are not paid at the end of the project, you have 90 days from completion to go ahead and record a lien against the property as well as serve that. In terms of a remote contractor, everything runs from the date of service. So you have to record it. You could record it after day 45, but you have to actually serve that on the general contractor and the owner within 90 days of completion. In terms of enforcement, again, prime contractor has 1 year. Prime contractor, if you've got a contract with the owner, you don't even have to record a notice of lien. You can just go straight to enforcing that lien through a lien enforcement lawsuit. Whereas with a remote contractor, you have to provide notice. You've got to record the lien in the Register of Deeds office to make sure that everybody in the world, not just the owner, is aware of your lien claim. And then you also have to file a lien enforcement action within 90 days of the date that you served the recorded notice of lien on the owner. So again, if you're a remote contractor, just remember the rule of 90. Everything you have to do has to be done within 90 days of something. And if you have any questions on that, feel free to let us know. But in general, I think everybody understands if you haven't been paid, you have a right to a lien, and it can be a very effective weapon in terms of providing security for any payment that is not made. In terms of the Truth in Construction Act, this is titled Current Truth in Construction Act. Really, it was the former because a lot of this went away for the commercial construction industry. But what that act requires was a pre-construction notice really it's a notice of lien rights. So if you had a contract with the owner, you were required to serve a notice that says, hey owner, I'm getting ready to do some services for you, or I'm going to be providing labor and materials to you pursuant to our contract. If I don't get paid, I can just assert a lien against your property. And not only can I do that, but any of my lower tier consultants or subcontractors, they can do that as well in most instances. The only exception to that being residential real property, but we're providing you notice that if you don't pay us, you're going to end up with a lien. It also provided a waiver of lien form that was required to be given to the owner after completion and after final payment was made. In both of those instances, there was actually some criminal penalties that go along with that, particularly with the pre-construction notice. And really, in the commercial construction context, you're dealing with sophisticated parties. They already know all of that information. And so what was happening was a lot of times you would see somebody where final payment was not being made. You were negotiating back and forth, and all of a sudden an owner says, well, you never gave me this pre-construction notice. And technically, you could go to jail for that. It's a misdemeanor. So up to, 11 months in prison, a fine of $50, and it could be continuing in certain circumstances. And really, it didn't serve a real purpose other than that, it was something that an owner or an owner's attorney would threaten every now and then. And really, there was no need for it. If you're dealing with residential construction, you're dealing with somebody that oftentimes it's their first introduction to the construction industry and the construction process. It's totally reasonable that you would provide an owner some sort of notice of what their rights are, what your rights are, and give them an opportunity to go ahead and cancel the project if there was some sort of issue that they weren't aware of after they have a chance to go ahead and review the contract before they actually retain you, before they pay you, before you start doing work in their house. Again, this is a statute that is primarily geared for consumer protection. It arose out of some of these cases that you hear most often with after a hailstorm, you have some fly-by-night person come in that swoops in, signs somebody up for a new roof or for some sort of project dealing with the hail damage. They go ahead and subcontract that to someone else, and even though they've been paid, they leave, the contractor does the work, they're ultimately not paid because somebody just ran off with the owner's money, and then the owner is facing claims from a lower tier subcontractor or consultant that they weren't paid and that they're going to be enforcing a lien against the property. In those circumstances, it really is a consumer protection issue, but it's not something you typically see in the commercial context. So ultimately, SIPA came about. This was an area where we saw a need for change. The other thing in the Truth in Construction Act that actually does apply to the commercial construction industry is a choice of law and venue provision that says if you're doing work in Tennessee on a Tennessee construction project on a Tennessee property, Tennessee law is going to control. Many times when you see a project, particularly with an out-of-state contractor or an upstream consultant that's doing work, they want their law to control, whether it's Kentucky, Alabama, New York, Georgia. Georgia is big on this, where Georgia wants Georgia law to apply. That's something that if it's in Tennessee, Tennessee law is going to apply, and we want Tennessee law to apply so that we can have a little more reliability and the expectation that whatever we think is going to happen on a construction project, is actually going to apply. We want Tennessee law to apply. We want the Prompt Pay Act to apply. And so that's something that we wanted to stick around. But really, that's the only aspect of the Truth in Construction Act that applies to commercial construction here in Tennessee. With the third is the current Prompt Pay Act. Formerly, this is something that applies only to written contracts in Tennessee. You can have oral contracts, you can have written contracts, you can have very sophisticated written contracts where sometimes it's a simple invoice or estimate that you see, one pager with maybe some terms and conditions attached to it. Sometimes on a large project, it can be a couple inches thick. The only requirement for the Prompt Pay Act is that it be a written contract. So what does the Prompt Pay Act provide? Well, it provides some general payment terms that say if you have a contract and if it says you're going to be paid within a certain period of time, that period of time is going to control. But oftentimes, even in the commercial context, we have contracts that are bare minimums. It says, I'm going to provide this service for this amount of money, and that's about it. In those circumstances, the Prompt Pay Act provides a default payment term that says everybody's going to be paid essentially on a net 30 basis within 30 days. If there's retainage that's going to be withheld, it can only be 5% of the contract value. That retainage has to be placed in a separate interest-bearing escrow account with a third party. And that retainage, although it can be withheld, has to be paid within 90 days of substantial completion. For substantial completion, that's typically what everybody thinks of as completion. It can either be an architect's certificate of substantial completion, it can be a use and occupancy permit, or it can be when the owner could have used it for its intended purpose. So if you're thinking about a house, a lot of builders have spec houses that are completed long before they're sold. And so if it's on that, retainage has to be paid within 90 days of when they could have used it for its intended purpose, regardless of whether there's a certificate of substantial completion and regardless of whether there's a use and occupancy permit. If you wanted to seek relief under the Prompt Pay Act, whether that be for some of the statutory penalties or statutory attorney's fees or interest, you had to provide a 10-day notice. That's again, to provide notice and opportunity to cure, give somebody a heads up that, hey, I haven't been paid, raise your hand, and then hopefully you get paid. If not, in addition to seeking those interest penalties and attorney's fees, you could also seek injunctive relief, which means you could go to the court and ask for an order requiring somebody to do something, whether it be the owner to make payment, the owner to execute a release of retainage to allow the general contractor or the prime design consultant to be able to withdraw that retainage and go ahead and pay it to its lower tier consultants. And again, in terms of applicability, it only applies when there's a written contract, but there is a big gap with the Prompt Pay Act historically in that it does not apply to banks, lenders, insurance companies, anybody that is not physically performing work on the project. That created a very large gap in that if you tried to go get retainage, that typically is going to be held by a third party, most often a bank. So if the bank is loaning money to the owner and they're not releasing that money, or if you have the bank holding retainage and for some reason they're either not releasing it, or if the owner's not allowing the general contractor to withdraw those funds, if you went to a court and asked for an injunction requiring the bank to release those monies because it's not theirs, it's the designers, it's the consultants, it's the contractor's money in Tennessee as a trust fund state, there was really nothing you could do. You went into court saying, hey, I've got a problem, and the court would look at you and say, yeah, I understand the bank should release it, but I can't order them to release it because the Prompt Pay Act does not apply to any sort of lender or insurance company here in Tennessee. And so there was a need to change that as well, make sure that there was some sort of procedure where everybody was subject to the same rules. Finally, in terms of the construction defect statute, this is again a statute that allows for notice and opportunity to cure for any design defects, for any construction defects. The issue with this law is that, one, it only applies to owner-initiated complaints. So if you are some third party that has an issue, excuse me, some third party that had an issue, or if it's a contractor that sees some issue with a subcontractor's work, or if you're a designer and you see an issue with one of your subconsultants' work, the statute didn't apply. It only applied for owner-initiated complaints. But even when the owner initiated a claim and said, hey, there's some issue here, somebody needs to fix this, the procedure is so detailed and so drawn out that if you are on a large project, particularly here in Nashville, if you take it to its extremes, like we did one time, it can take anywhere between 3 and 6 months to get notice from the owner all the way down to lower tier consultants, have them come out to the project, figure out what's going on, send a proposal up and downstream. And by the time you actually get to a point where somebody could do some work to repair it, again, 3 to 6 months has gone by, which doesn't really do anybody any favors. And so this is something that is rarely used. I'm only aware of a handful of times here in the past decade that somebody has actually gone through this process. More often than not, there is a notice and opportunity to cure procedure that is contained within the written contract between the owner and the GC, or the GC and the subs, or between any of the design consultants, so that if there is a problem, it's handled much more efficiently through a written contract than actually having to go through a very lengthy procedure through this statute. So that's kind of where we were. The question is, how did we get to where we are now? And some of you will recall in Tennessee, we have a 2-year legislative cycle, meaning there are 2 years, even though the legislature is only in session between January and generally late April, early May of each year. If at the beginning of a session, all of the legislative issues that are going to be taken up are filed in January, early February. So if there's a bill I want passed, I have to file it early on in the session. That goes through that first session, and if most of those bills do not pass. If they're not passed in the first year, they automatically roll over to the second year and can be taken up again. So one of the bills that was filed by the American Subcontractors Association was House Bill 271, Senate Bill 324, which wanted to make a number of changes to all of Tennessee's construction statutes. This is something that personally I took an interest in, not because of what it wanted to do in terms of one of the key issues here, which is invalidating pay if paid clauses in Tennessee, but really how it was going about doing that. As I mentioned, one of the things that Tennessee is very good about in terms of the construction industry is that oftentimes the construction industry, because it's a relationship business, works out any sort of dispute at the lowest possible level, and typically fairly early on in the process. So that in terms of litigation, we don't see a whole lot of construction lawsuits that actually go through trial, go through the Court of Appeals, and give us what is case law that binds other courts. A lot of times, 99% of the time, those cases settle, whether it's with an attorney or before it ever gets to an attorney. And so there's a lot of construction law that everybody knows that hasn't actually been decided by a court. If somebody does have an issue, they typically take it to the legislature, and they're generally focused on one specific issue. The Tennessee construction statutes are very, very broad in terms of their coverage. They're very detailed, and they contain many, many sections within each individual statute. The problem is somebody sees one issue that they have within one section, and they want to change that one section, which is fine, because in most instances, it addresses the issue and everybody moves on, the construction industry moves on, and things keep rolling. The problem is a lot of these statutes well, not a lot of them, they're all interconnected and intertwined. They all use the same terminology that is given in the construction lien statutes. And so if you have a change, it may be perfectly acceptable to you, but you don't always know some of the unintended consequences of that change. So as I mentioned earlier, back in 2007, there was a huge change and a comprehensive change to the mechanical lien laws that totally did away with a lot of definitions. Previously, again, a lien was determined by who you were, whether it was a general contractor, subcontractor, supplier, architect, engineer. And so when we introduced the terms prime contractor and remote contractor, all of those terms went away. And so one of the things that the subcontractors wanted to do was reinsert a definition of subcontractor, as well as the term work completed into the lien laws, which personally I had a problem with because the term subcontractor does not appear in the lien laws. And so there really wasn't a need to reinsert that definition. It was just something that was going to create additional ambiguity. Courts typically, because they don't see a lot of construction cases, have one of two reactions when they get a construction case. One is they get really excited because they're somewhat interested in it, and it's not something they typically see. The other is that they have no idea what it is because they don't see it, and they really don't pay a lot of attention to it. Either way, it's something that is going to be relatively new to a court, and they already have enough trouble trying to figure out what's going on within the construction industry. So inserting terms that are never used was just going to confuse courts and make it even more difficult to try and seek relief if you did have a dispute that rose to that level. In terms of work completed, the statutes refer to substantial completion and completion. Substantial completion is a defined term within the Prompt Pay Act. Work completed never appears, and if you want to define completion, you can do that, but it's got to go through a process and can't be something that's just unilateral with one group, just because of the way it affects everybody else. One of the prime changes the subcontractors wanted to make was 90 days seemed to be a little restrictive. in terms of how payments are passed through and how payments are made in the construction industry nowadays. 90 days seems like a long time, that's 3 months, but realistically, if you're a subcontractor, even if we say everybody's going to get paid on a net 30 basis, which does not happen, more often, a subcontractor or a design sub-consultant is going to have to provide their pay applications by the 10th, 15th, 20th of a month. Those get passed upstream. The full application is going to be sent to an owner on the 25th of the month, and then hopefully you get paid within 30 days of that. So if you have a pay application that you're submitting on the 15th, you're not getting paid, even as a prime contractor or as the primary design consultant, until 30 days after that. You're already 45 days out. Realistically, there's going to be some lag time. A lot of these big projects, you've got several tiers of consultants and subcontractors. And so it's really more realistic that you're going to get paid somewhere around 60 to 70 days after you submitted your initial pay application. That only leaves you about 15 days to make a decision on whether you're going to send a notice of non-payment, whether you're going to record a lien. As a relationship business, do you really want to upset the apple cart and start doing that early on in the project? And so it was a decision to try and see, well, what if we extend that a little bit? If we push it out a little bit, that gives us more time, not only to make sure we've got our own I's dotted and T's crossed, but give the owner and the upstream contractors and consultants an opportunity to try and push a little harder to make sure that payment's going to come, as opposed to starting a dispute on something that may or may not, at the end of the day, be a big deal, and is going to require you to take some action and incur some expense on the part of the designer and the subcontractor to be able to get paid. Another, in terms of not only the notices of non-payment and time to record and serve notices of lien, was also extending the time for a lower tier consultant or subcontractor to actually file a lien enforcement lawsuit. Right now it's 90 days. They not only wanted to extend that to 120 days, but push it out to 1 year. Again, good, bad, and different. That was something that was getting a lot of pushback from ownership groups, particularly lenders, because when they go through a project, at the end of the project, when it's complete, they convert from construction financing to traditional financing. And they have to take a lot of steps, one of which is to make sure that there's no encumbrances on the property. Right now at 90 days, you can go ahead and get lien waivers. You can bond off liens. You can take actions as a lender, as an owner, to try and protect yourself. But if you extend that to 1 year, normally you're only looking at the general contractor, and as long as the GC's paid, there's no harm, no foul. The risk of having a lien enforcement lawsuit is relatively low. The same thing if you're dealing with a primary design professional. You know who they are. You've got a contract with them, and as long as they're fully paid, you wouldn't expect as an owner or as a lender to see a lien enforcement lawsuit. But with any number of subcontractors, extending that out to a year was going to create some additional issues. Another was reducing the time period for retainage from 90 days to 30 days in terms of when that had to be paid. For those who've been in business for at least a decade, I'd say, you may recall that historically retainage was retainage when it applied to contractors. A lot of times an owner would withhold 10% as retainage. And at the end of the project, if there were any punch list issues, if there were any defects that had not been cured, an owner would simply take that 10%. They'd fix it, and then they'd pay whatever remained to the general contractor. You really don't see retainage so much in the design profession, simply because if there is a design issue, a lot of times it's taken care of during the construction process, or it doesn't manifest itself until some time period later when something happens. But historically, that's the way that retainage worked. A number of years ago, retainage was changed to where it was really more of a completion guarantee than anything else. It was determined that retainage was money that was being withheld on work that had been performed properly. And Tennessee being a trust fund state, the legislature decided that if we're withholding retainage for work that has been completed in accordance with the contract, that money actually belongs to the contractors and the designers to whom it was withheld, or from whom it was withheld. And so at the end of the project, there's no reason that money should be used by an owner. It belongs to another party. It's being held in trust for those parties by a third party. And so the only thing an owner can do is withhold it within a period of time, right now 90 days, as really as leverage to try and get a party to do some action. If there's defective work, to fix it. If there's a design issue, to take a look at it and see if there's something that can be done to address whatever issue the owner is having. If at the end of the day, if it's not, whether or not it's taken care of to the owner's satisfaction, an owner still has to release that money within 90 days of completion. And so one of the things that you see is, even though we have that rule of 90, a lot of times owners weren't doing that. And so to try and reduce the amount of time that contractors and consultants were having to wait on money to be released to them, it was shortening that from 90 days to 30 days, so that if a subcontractor or a GC wanted to go ahead and seek relief under the Prompt Pay Act, they could go ahead and do that 30 days after completion, as opposed to having to wait 3 months and really just continuing to finance a project. The biggest issue with this bill was that it invalidated contingent payment clauses. These are frequently pay if paid clauses, but there's really 2 types: pay if paid and pay when paid. Pay when paid is more of a timing mechanism. It says that I'm going to pay you once I get paid from whoever I have a contract with. Pay if paid clause is an express condition precedent, meaning I only have to pay you if I get paid. And so it's very clear, with pay when paid, generally the most you can get off of that is about 90 days. Whereas pay if paid, if an owner defaults, if an owner files bankruptcy and they don't pay the GC or the primary design consultant, nobody gets paid. And it's more of a risk shifting mechanism than anything else. It also created an ability for subcontractors to stop work. This is a procedure you already see in most of the AIA documents, where if a contractor or if a subcontractor is not being paid, they can raise their hand, they can send a notice upstream and say, hey, if I don't get paid within 10 days, 7 days, or whatever period is within the contract, I'm going to stop work and I'm not going to go back to work until I get paid. You see it a lot of times with a demand for adequate assurances. So not only are you going to pay me up through what I'm owed now, but you also have to show me that you can pay me from this point forward. So at the end of the day, there was a lot of opposition to that bill. It did not pass in the first session through 2019, and that led to a meeting that was called by the Senate sponsor, Jack Johnson, for anybody that had an interest in the bill to come and sit down at a meeting and discuss what was going to be an amendment to the bill that was going to strip it down to really only address the invalidation of pay if paid clauses and the stop work notice procedure. Although that's what it was intended, there were a number of groups that attended that meeting, including the American Subcontractors Association, the Associated Builders, good night, I can't talk today, sorry. The Associated General Contractors of East Tennessee down in Chattanooga, as well as the Associated General Contractors of Tennessee here in Nashville, the ABC of Greater Tennessee and West Tennessee, the AIA, ACEC, NSPE, and I put a Lewis Thompson hard hat there, but really there were a number of attorneys that were there as well, both on behalf of the Tennessee Bar Association, which looks more into not the merits of what a bill is, but whether it's something that will create good legislation here in Tennessee for any entity that's involved. Here we're talking about the construction industry, as well as the Tennessee Association of Construction Council. And while we were in that meeting, it really transformed to a realization that how many times do you have everybody within the construction industry focused on one specific thing? A few moments ago, I talked about the way a lot of legislative changes are made here in Tennessee. It's specific to one particular party or one particular part of the industry has an issue, and they want to change one specific thing. Well, that's fine in one instance, but we've been doing that. The Prompt Pay Act, for instance, was enacted in 1991. There have been 30 years of that. And so there were plenty of instances of ambiguities, inconsistencies, not only within one specific statute, but all across those statutes. And so instead of focusing on what one party had an issue with, which was subcontractors had a concern, and not a concern, but it was a fact that they were not receiving payment. Instead of trying to shift that between the industry, whether it be from subcontractors to general contractors, or from subconsultants to prime consultants, what is the issue that we're really all facing? And that was, well, let's reframe it. The issue is not one party needs payment protection, it's that the entire industry needs payment protections. We all have these current construction statutes that are intertwined and provide us some protection. But as we talked about a little bit ago, because of all the changes that had been made on a piecemeal basis, they were inconsistent and they clearly were insufficient to protect the industry as a whole. The bigger problem was that the risk of non-payment was not borne by the party that was best able to manage it. A lot of times in any sort of construction contract, when we're dealing with insurance, the obligation to provide insurance falls on the party that's best able to manage the risk. You know, non-payment should be the same way. Instead of the industry fighting amongst itself, saying, well, I shouldn't bear the risk, you should bear the risk, we really needed to refocus and say, well, why are any of us bearing the risk? You know, this is something, if the owner is the one who is getting the money, if the owner is the one that's going to be obtaining the benefits of all of our work, our labor, our services, why shouldn't the owner be the one to bear the risk of non-payment, or really the obligation of payment? And so once we got to that point, it was, well, how do you resolve this problem? Well, one is internal consistency. You know, if you don't have a statute that makes sense, it's certainly not going to make sense to a court when they go to apply it. The second was we've got to eliminate loopholes in all of these relevant statutes. Most notably, you know, you have a bank, which is very much a part of the construction process, where the Prompt Pay Act doesn't apply. Not only does it not apply to projects they're involved in, it doesn't apply to their own projects. So if a bank went out and wanted to have a new call center or wanted to have a new branch, you know, they were not required to withhold retainage in accordance with the Prompt Pay Act. They weren't required to make payments in accordance with the Prompt Pay Act, or really even their contracts, until you had to go to a court to enforce all of that. There was no separate procedure that guided any of the dispute resolution provisions, or provided an avenue for relief if the bank wasn't going to comply. But most notably, you had to make sure that all of those statutes had adequate timing, notice, and penalty provisions to protect the industry as a whole. Now, as that meeting wrapped up, there was a need to get, you know, consensus amongst the industry of, well, okay, well, now we've recognized what the problem is and we have a general idea of how we can move forward from here, but how do we actually do that? So I was volunteered and voluntold to serve as the liaison initially between general contractors and subcontractors, but also be able to bring in opinions from the AIA, the engineers, the architects, the surveyors, suppliers, you know, some ownership groups, anybody that had an interest in any of these statutes, to be able to come up with some sort of solution. So through a series of meetings from June and July of last year up until really about May of this year, the general contractors and subcontractors got together to try and come up with some changes that would better manage risk, that would provide some additional notices and forms for particularly subcontractors to be able to enforce their rights without having to go out and hire a lawyer every single time. You know, there are a lot of things, particularly you know, initial design or defect notices, initial payment notices that are already contained within form contracts throughout the industry, whether it be AIA forms, EJCDC forms, consensus docs. You know, these are things that a lot of people, depending on which form you use, it doesn't really matter, but everybody's familiar with the procedure that you go through to resolve disputes. And even if you're not familiar with the specific provisions of one particular form contract, you have an idea of just generally through common sense how things should be managed and how disputes can be resolved. And so there was an idea of, hey, if we do this already, let's just provide some things that we know will work if we actually have to go to court. I don't want to have to hire a lawyer every single time that I need to send a notice of non-payment. You know, we already have a form for that. That's great. Same thing with a notice of lien. But in terms of if I want to assert my rights under the Prompt Pay Act, how do I go about doing that? It tells me I have to send a notice, but it doesn't have a form for it. So there was a need to provide some additional forms and notices to make sure that all of the consultants or subconsultants, general contractor, subcontractor, any form or notice that they had to provide, that they could actually provide that themselves without having to go spend money to hire a lawyer. The other is in terms of stop work and demand for reasonable assurances. We talked about those earlier. Those are both things that are already in many of the form contracts as they exist already. You know, there's no sense in reinventing the wheel. Is there a way we can borrow some of the ideas and procedures that we've already got in place and make them mandatory, so that if we're in a situation where we don't have any bargaining power, you know, whether it be negotiating with an owner or a higher tier consultant or general contractor, is there something we can protect ourselves with, where even if we don't have an opportunity to put it in a written contract, that it would still apply. The two final things that we looked at were, one, in terms of defining an action. Many of you will recognize that in Tennessee, we have statutes of limitation. For any contract, that's generally 6 years. So if I have a contract and I'm not getting paid, or if there's some other breach, whether it be by an owner or a contractor, I have to bring an action within 6 years. If it is a claim for property damage, that's 3 years. If I get in a car wreck and I'm hurt and I have a personal injury, I have to bring it within 1 year. You have all those statutes of limitation that apply to any sort of cause of action that could arise. Within the construction industry, though, we also have what's called a statute of repose, which says it doesn't matter what type of claim you have, whether it's for personal injury, property damage, breach of contract. If you have a claim, it has to be brought within 4 years of substantial completion. There's a little exception to that, where if some sort of damage or personal injury happens within the 4th year, you have 1 year from the date of that injury or the date of the damage to bring it. So you can have up to 5 years, but there's an absolute limit on when claims have to be brought for anything having to do with the construction project. Historically, just again, because Tennessee is not very litigious, everybody assumed that that statute of repose applied both to litigation, if there was a case brought in a court, as well as to if there was an arbitration demand. That's something that happens often in construction contracts. Somebody doesn't want to go to court. They want to try and go the path that was historically seen as the quicker, cheaper, faster way. And so they would go to arbitration. I personally think arbitration is just as expensive, if not more so, than litigation, and you don't get all the benefits that you have in court with discovery and an ability to get immediate relief if somebody's not following the rules. Again, evidence rules don't apply in arbitration, but the issue was, everybody thought that the statute of repose applied equally to litigation and arbitration, up until about 1.5 years ago, when there was an arbitration case that was dealing with a claim that was about 7 years old, if memory serves, and something that would have clearly been barred had it been brought in a court of law. The issue was the way that the statute of repose was drafted was that it referred to the filing of an action, which was defined somewhere else as being only a court action. And so we had a situation where an arbitration award came out that granted a sizable amount to a entity that really should never have had a claim, only because the way the statute was written, the statute of repose did not apply to arbitration. And so there was a need to switch that and make sure that it was clarified that the statute of repose applies generally, so that it doesn't matter whether you're going to arbitration, litigation, or some other form of binding dispute resolution. You have to make a timely claim, regardless of whether you're a party to a construction contract or not. So third-party claims, if a project's completed, you have a slip and fall 6 years down the road, it makes clear that, sorry, you're not going to be able to go after the design team. You're not going to be able to go after the general contractor. You're going to have to rely on the general rules of, hey, the owner's there. They should have cleaned it up. They didn't. The owner certainly has liability, but as for everybody that was involved in the design context or the construction of the project, there's not going to be a claim. The final aspect that we looked at was making sure that limitations of liability were allowed in construction contracts. In most contracts that you see not only express limitations of liability, like you would see if you're a design professional, where you say, regardless of if there's any damage, and what that damage would be, my limitation or my liability is going to be limited to either my fee or some amount, $100,000, $200,000, $300,000. You pick it. Those are frequently utilized in the design context, but you also have waivers of consequential damages, liquidated damage caps. There's a number of different types of damages that are limited by contract. And generally, the industry said, well, we think those are valid, but there's not actually been a Tennessee case dealing with them specific to design professionals or specific to contractors. And so there are some trial opinions, meaning the first act when a court first hears it. There's no court of appeals case on it. There's certainly not a Tennessee Supreme Court decision dealing with it. But there is a series of factors that courts look at to determine whether a limitation of liability is permissible. The first of those is, does it violate the public policy of the state of Tennessee? That's something that is very fact intensive. It looks at, what the amount of the limitation is, whether it bears a reasonable resemblance to the risk that's involved. Were you dealing with sophisticated business entities, and did the parties have equal bargaining power? A number of different things for it to look at, but really, there still was no reported decision on whether or not those would be valid or not. And so one of the aspects that we looked at was, well, maybe we can insert something into the statutes that says limitations of liability are valid. And at least, if not that, to say that they don't violate the public policy of the state of Tennessee. And by doing that, you take out a huge question mark in terms of enforceability. And so now it is much more likely that a court is going to look at limitations of liability and say, yes, in fact, they are enforceable here in Tennessee. So specific to the changes, there are a number of changes that were made throughout the Construction Industry Payment Protection Act to better the industry. In terms of the lien laws, despite the attempts to try and look at a couple of things to, for subcontractors to make it a whole lot more likely that they're going to get paid, extend some deadlines, there really weren't any substantive changes that were made. It really boiled down to, well, these are some things we're looking at, but let's table them for later and focus on something that's a little more big picture. In terms of the lien laws, there weren't really any substantive changes. The changes were primarily geared towards some of the definitional and terminology changes that had been made in the past, making sure that those were carried through throughout the entirety of the mechanics lien laws, as well as the other construction statutes. With the truth in construction, as we talked about earlier, there were some minor changes to some of the record keeping requirements that applied to residential only, not to the commercial context, but removed the criminal penalties or the potential criminal penalties for non-compliance with the pre-construction notices, the lien waivers at the end of a project, to make sure that, both an owner and a designer, or an owner and a general contractor, they're both sophisticated entities. They've both been in the construction industry a while. There's no need to try and penalize them for really what is just a record-keeping error or oversight. And so this one was, I say, a substantial change in that it no longer applies to the construction industry or the commercial construction industry, but really there weren't a whole lot of people who were following it to begin with. So what it did was, take out the little trip that could have existed by the failure to provide some of those initial notices and get rid of some of the criminal penalties. Where the big changes happened were within the Prompt Pay Act itself. Again, providing additional forms and notices, clarifying that a subcontractor or a subconsultant, if you're a designer, has an express right to jump not only the general contractor, but the principal designer if they're not being paid. You can go in terms of injunctive relief. If an owner's not making payment, you can seek an injunction directly against the owner and potentially against the bank in some instances to go ahead and release money that would be due to you. Again, you have to provide a 10-day notice, but instead of having to go through a full trial, there is a procedure, and that can take up, at least a year, realistically closer to 2, potentially 3 to get your money. There's an expedited procedure where you can seek injunctive relief, post a bond, and get a court order that requires an owner or a lender to go ahead and release money so you don't have to be sitting there financing a project. That was, the lenders like to think of themselves as the financiers of construction projects, when realistically, it's the designers, it's the general contractors, and it's the subcontractors and suppliers that are supplying all of the materials, on credit, on terms of at least 30 days and realistically, most of the time, 90 days without getting any sort of interest on that money. And so, by being able to go ahead and jump in line and require that to be paid, you're essentially cutting that off. In addition to that, historically, the interest rate, 10 years ago was 10% just as a matter of law. Any progress payment that was not made within, the whatever time period was in the contract, or if there wasn't one, 30 days, according to the Prompt Pay Act, accrued interest at the rate of 10% per month. That was changed a number of years ago to be a prime plus rate, which changed every 6 months. So even if you wanted to go to trial, to be able to obtain interest, you would have to retain an economist to come in and do all the calculations that would be necessary to say, okay, on this date and for this portion of the amount that's owed, it's this rate, but then it changed here, and it just became unmanageable. So there's actually two Prompt Pay Acts in Tennessee. One is the Prompt Pay Act of 1991, which applies generally to the construction industry. The other is the Prompt Pay Act of 1985, which applies to government purchases that are not construction. If the government is buying ballpoint pens, desks, any sort of furniture or other furnishing that's going into an improvement, they pay 18% per year on any amounts that aren't paid. And so the idea came, well, if the state's paying 18% per year for ballpoint pens, why shouldn't they pay 18% on, payments that are due designers on state projects, or payments that are due general contractors on border region projects? And if we're requiring the state to pay 18%, why shouldn't everybody pay 18%? It's frequently the interest rate that you see on any sort of supply contract, whether it be for materials or equipment, whether it's rented or purchased. And so, it's something that actually provides a legitimate benefit to the industry. If you're not being paid on time and in accordance with the contract, at least you're going to get interest that reflects that and reflects the fact that you're financing the project. The final changes were in terms of demands for adequate assurances and rights to stop work. This is, if you read the statute, it is very similar to what you would see under an AIA contract, with the only difference being some of the timing. So in terms of mechanics liens, we have that rule of 90, where everything for a remote contractor is 90 days. 90 days to provide notice of non-payment, 90 days to record a lien, 90 days to file a lien enforcement action. With the Prompt Pay Act, it's really the rule of 10s. You have to provide a 10-day notice of your intent to seek relief under the Prompt Pay Act. If you're not paid, you can serve a notice of that you're going to stop work within 10 days of providing the notice. It's essentially an opportunity to raise your hand and say, you know what, I've been financing the project up to this point, but I'm done. If I don't get paid, I'm going to stop work. That notice requires an owner to send some sort of response back to whoever sent the notice, as well as any upstream contractor or consultant. If there's actually adequate legal reasons for the non-payment, whether it be defective work, work that's not completed, work if you're on a project completion basis, if you say it's 75%, but it's only 50%, those are adequate legal reasons not to make payment. If there is an adequate legal reason not to make payment, you obviously can't stop work. But assuming there's not, and it's just simply a failure to make payment, if you're not paid within 10 days, you can stop work. Once you are paid, if you're subject, time is of the essence provisions. Normally, if you're a designer, you strike those immediately, but to the extent they apply or you're otherwise bound to some sort of project schedule, if you stop work, you're finally paid, you are actually entitled to an equitable extension of the project schedule equal to the amount of time that you had stopped work. Another instance of that is, along with both of those, your intent to seek relief under the Prompt Pay Act and your intent to stop work, you can also, if you're not paid, file a demand for adequate assurances, again, to make sure that not only are you going to be paid for everything that is due currently, but you're also going to get paid for everything moving forward. A lot of times a general rule of thumb is if you have a project of, pick an amount, $1 million, something small, or $100 million. Generally, it's not uncommon to see about 10% of the contract value in change orders. And so if you get, 90% done, you still have 10% outstanding. 5% of that is going to be retainage if you're a contractor. It's not uncommon to see an owner get to the end of the project and run out of money, essentially just because they paid an extra 10% for the change orders. So, the goal is early on in the project, increase communication and make sure that an owner actually has money that's going to be sufficient not only to pay for the project itself, but any sort of changes that arise along the way. The goal of all of that is better manage risk, making sure that an owner is going to have sufficient money to be able to pay for the project and actually makes payment on time. One of the things that it's a minor change in terms of how it was changed. It's a big change in terms of the potential effect. We talked about retainage. If retainage is withheld on a project, on any project that's over $500,000, retainage has to be paid into a separate interest-bearing escrow account that is held by a third party. If an owner, generally that falls on the owner. If the owner doesn't properly withhold retainage or put it in a proper account, that obligation falls on the general contractor. but regardless, it still has to be held by a third party in a separate interest-bearing escrow account. If it's not, the Prompt Pay Act has always had this $300 per day penalty. And it used to be penalty, but that created some issues. $300 a day, if you do the math, is roughly about $108,000 per year. So that would be payable to a contractor or a consultant that has retainage being held. It is a very punitive statute. There are no defenses that are available for it. It's absolute, so that if that money is not withheld, $300 begins to accrue the day it is first withheld. So on a lengthy project, you could theoretically have several years worth of, instead of $108,000, you're going up sometimes to $500,000 in damages that continue to accrue. The problem with this was that there was a court here in Nashville that decided that as a penalty, there is a constitutional prohibition that says you can only have 1 year's worth of statutory penalties. And so, the idea behind this originally was that, you were going to have a punitive measure that was going to deter owners from putting retainage in accounts that were not compliant with the Prompt Pay Act. If you have a case out there that says you're only entitled to a year, obviously that takes away some of the leverage from a consultant or general contractor at the end of the project. If they're saying, hey, you owe me this principal amount of, $1 million, but you also owe me $500,000 in penalties, it certainly takes some of the thunder away from that. If at the end of the day, you can really only get 1 year's worth. That was never the intent, was only a year. It was supposed to go from the initial withholding until it was paid. And so there was a change from penalties to damages to try and get around that. Whether or not that's going to be sufficient remains to be seen. It will have to be taken up by the courts again. But again, the goal of that was to make sure that those damages would actually be available. Again, the Prompt Pay Act, some of these changes were to clarify that regardless of who you were in the contracting chain, you could go directly against the owner to try and get an order making sure that the owner was going to make payment. You could go to the court and say, hey, court, order them to release retainage or order them to make this progress payment. You don't have to wait to the end of the project to do that. It's something that can be done on a summary motion proceeding. So instead of waiting 2 years to get a progress payment, you can go to court and realistically within 60 to 90 days, go ahead and have that money released. The other was that a lot of times, regardless of whether it was a progress payment or retainage, if an owner defaulted or filed a bankruptcy petition, you would have a lender say, well, I'm not giving any more money to this bankrupt party. Sorry, you're out of luck. The person you have a contract with defaulted, you got to go look for them. That created a lot of issues, particularly with pay if paid clauses. And so there was a need to clarify that it doesn't really matter if the owner or an upstream contractor is bankrupt or has otherwise defaulted under the contract. It's not a defense to non-payment. And so, as we'll talk about here in a second, one of the keys for all of these changes was making sure that the Prompt Pay Act actually applied to banks. It's worded a little funny, but at the end of the day, if a bank is not making payment, you can now go and get an order against a bank, and a bank is required to comply with that order and either release retainage or release other funds that are held in trust for the designers or the contractors. And so, the bankruptcy or default of another party is no longer going to be a defense for a bank to be able to say, well, we're not going to pay you because we're not obligated to fund the owner. Well, that may be true, but you are obligated to fund the consultant and the general contractor now, which is a huge change. We talked about interest a little bit. Again, just know that now it's actually sufficient to compensate consultants and contractors for having to finance a project from the outset. Talked a little bit about notices again. Similar to the lien statutes, which already provide forms for notices of lien and notices of non-payment. The Prompt Pay Act now has a form notice of your intent to seek relief under the Prompt Pay Act. It also contains notice for stop work, just a statutory notice that can be copied and pasted into a letter, and the same with a demand for reasonable assurances. Now, if any of you have been subconsultants on project or subcontractors, you know that you can send one notice that covers multiple months in terms of notices of non-payment. So if I were January, February, and March, and I'm not paid, I can send one notice by the end of April that covers all 3 months. The idea is the same under the Prompt Pay Act. If you're going to seek relief under the Prompt Pay Act, you shouldn't have to send 3 notices. you can just copy and paste all of these into a single letter and send it. So you can make, or you can provide notice of your intent to seek relief under the Prompt Pay Act. You can send notice of your intent to stop work. And you can also demand that the owner provide evidence that they've got sufficient money to be able to pay you, not only for what's owed, but what's going to be owed in the future, all in the same letter. And again, probably the biggest change of all of this is the fact that lenders, insurance companies, any other savings and loan or other financial institution is actually subject to the Prompt Pay Act now. There were a series of, this initially was going to go away completely so that it would be very clear that the Prompt Pay Act applied regardless of who you were, and that it totally got rid of the banking exemption. But March rolls around and then COVID hits. And so the legislature had passed, at least in the House, an initial version of the bill. And as part of this whole exercise in making these changes, there were some deals that were struck with the state of Tennessee as well as the Tennessee Bankers Association. COVID hits, and both of those parties reneged on some of their deals. And so in what I'm calling the COVID compromise, right before the legislature went back into session, there was a new deal to get rid of some of the opposition by the Tennessee Bankers Association. And so the blanket banking exemption technically still exists in Subpart A, which says the Prompt Pay Act doesn't apply. And then there's a big but, and it says, but it doesn't apply if the bank is acting in the capacity of an owner. And that means whether they're doing their own project, whether they take over a project on behalf of a defaulted owner, or whether they inherit a project from somebody else. In those instances, they then have to comply with the Prompt Pay Act. The only caveat to that is that a bank doesn't have to place its own retainage with another bank. They can hold the retainage themselves. So it gets rid of that third party requirement. However, regardless of all of that, and again, it's extremely confusing when you read it, but it's very straightforward in practice, is that it doesn't matter if the bank is working on its own project or if the bank is just acting in its traditional capacity as a lender. If the bank is holding any money, and that means the original construction loan proceeds or retainage, if the bank is holding that money and it has become due but has not been paid to either the contractor or a design consultant, you can get an order from a court that requires the bank to release that money and pay it directly to the contractor or the design consultant. And again, that's huge in terms of timing, because instead of having to go through a 2 to 3, 4 year battle to actually get a judgment from a court before you can enforce your rights and actually get some sort of recovery, now you can go through a summary procedure to get an injunction directly against the bank to go ahead and get that money paid to you. Again, in terms of limitations of liability, I'm going to try and wrap up real quick. Just know now Tennessee has an express statement on record in statutes that say limitations of liability are not against the public policy of the state of Tennessee to the extent they are contained within a written agreement that applies to the design, planning, supervision, observation, repair, or construction of any improvement. So generally, if it's in the construction industry, limitations of liability are going to be valid. And finally, in terms of the construction defect statute, not a lot of changes there. That's again something that's rarely used, and because of the time crunch and COVID, it was just decided by the industry, we're not going to worry about that right now. Nobody uses it, and we'd be better off just modifying our contracts and enforcing the rules that we've got in there. And finally, with the statute of repose applies regardless of whether it is in litigation, arbitration, or any other form of binding dispute resolution. So I haven't seen any questions yet. If you have any, feel free to type them in now and we can take a look at them. Otherwise, you can feel free to contact me at my email address, which is wurban@lewistomason.com, or give me a call at 615-259. It says 1377. My phone number direct is 259-1377. You can give me a call. Otherwise, appreciate you being on today. Kind of rushed through the end, but giving you kind of a high-level view of all the changes that were made through SIPA. And again, if you got any questions that are specific to a particular statute, feel free to reach out to me. Again, this is part of what we would normally do as an annual one-day, full-day seminar that we've broken up into a number of different units. If you have any interest in, and we hope you do, in participating in any additional sessions that we've got, next week we're actually going to have another session on considerations for getting paid during the COVID-19 crisis. In October, we'll be looking at some employment law considerations for design professionals and contractors in a COVID age. That will deal specifically with some of the news stories you've been hearing about potential liability and some of the legislation that was passed here recently. And then finally, to the extent that you do any contracting yourself, or you're dealing with a project where a contractor is not licensed, we'll have an attorney talking about some of the issues that arise with unlicensed contracting. But again, appreciate your time today. If you're interested in any of those sessions, email Tanya Freeman at tfreeman@lewisthomason.com, and hope you have a great rest of the week. Thanks very much.